The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain petitions for allocation of parenting time and responsibility in Illinois. So some foundational information. Back in 2016, the law changed so that courts, instead of referring to parenting time and responsibility as custody and visitation, now talk in terms of a sliding scale of parenting time. So it's not one parent having custody, the other parent getting visitation. It's how much parenting time each parent gets. And that is in order to reduce the feeling of having a winner or loser in a parenting situation. So now we talk about petitions for allocation of parenting time and responsibility instead of petitions for custody. So this petition for allocation of parenting time and responsibility can be combined with a petition for divorce, for paternity, legal separation, or an order of protection. And in this case, the allocation of parenting time can be baked into one of these other types of cases. Or it can be a standalone petition. So if you've already established paternity, but you haven't established parenting time, you can later go and file a petition for allocation of parenting time and responsibility and have it be a standalone case. If you are filing a petition for parenting time and responsibility as a standalone case, it has to be filed in the circuit court in the county in which the child resides. Now, venue and jurisdiction issues are a little bit more complicated than that. That's the general rule, but we have an article and video about jurisdiction in child custody cases if you want more detail. But the general rule is that it should be filed in the circuit court in the county where the child resides. It'll be filed along with a summons. A summons is a document that tells the other parent that the case has been filed and where and when the first court date will be, and you will deliver the file stamped summons and petition to the sheriff of that county, and the sheriff then will effect personal service on the other parent. If the sheriff is unsuccessful in serving the other parent, you can hire a special process server, which is basically a private detective that can track down the other parent and get personal service. It's not just enough to mail notice of the petition to the other parent. In order to initiate the case, the other parent has to be personally served, which again usually means sheriff or special process server, but there's certain types of certified mail that will also do for this. Once the case has been opened, the parents will have to undergo mandatory parenting classes as well as a mandatory mediation in order to come up with a parenting plan that's agreed. This is known as a joint parenting agreement, and this deals with how parenting time and responsibility will be divided among the parents. If the parents are not able to come to a joint parenting agreement through mediation or otherwise, then there will be a trial at which time the court will try to determine what the best interest of the child is. In cases like this, there will usually be a guardian ad litem appointed in order to investigate what the best interests of the child are and then report back to the court. The guardian ad litem is a family law attorney who's there to advocate for the child's best interests, advocate for the child's best interests and report to the court as to what the child's best interests are. So if the court does have a trial about how parenting time and responsibility are going to be allocated, again, the rule of thumb is what is in the best interest of the child. And at the hearing, the court will weigh several factors. They'll look at all the facts of the case, but the factors that statute instructs them to consider are the wishes of each parent and the wishes of the child. The older the child is, the more their wishes are taken into consideration. The child's past relationship with each parent, siblings, and other loved ones, and how the living situation that's proposed would impact those relationships. The child's adjustment to home, school, and community, and how the proposed living situation would impact that, and which parent has been the primary caretaker up to this point. And again, the court will look at anything else that's relevant to the best interests of the child. At the conclusion of the case, the court will enter an order that lays out parenting time and responsibility, and this is very difficult to challenge within the first 2 years of the order being entered. It becomes easier to challenge based on a change of circumstances after the first 2 years, and this is because courts want a little bit of stability for the child, and they don't want parents going back into court after a final order has been entered every couple months trying to argue about parenting time. So if you have any questions or if you need help filing a petition for allocation of parenting time and responsibility, feel free to give us a call at 630-324-6666. That's 630-324-6666. 324-6666. General questions can be left below the blog post at learn-about-law.com or below the video on our YouTube station. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.